I'm just talking about this. This agreement has been exhibited on. Did you say that you never got the money in cash? Was it your case that you did not ever receive anything on cash?
Let me see the deposition.
Now then the second question would be, you want to argue that this check was issued not for payment of this debt,
Yes,
but for some other purpose.
Yes.
कंप्लेनेंट ने मुझे बैंक से लोन दिलाने का आश्वासन दिया, इसी आश्वासन के साथ मुझसे ब्लैंक चेक लिया है. बैंक से लोन लेने का इस आश्वासन से क्या लेना देना?
He was working as a bank officer. No.
So what?
The complainant.
Now, how does that make a difference? We don't know how this blank issuance of blank check can be correlated to a.
Yes.
Where is that cross-examination of the complainant on this point?
That is not there in this.
Then the entire evidence of the complainant is intact. So agreement, on the date of the agreement, the amount was not advanced as per the complaint. Further पढ़ी. एविडेंस में आप बोल दिए कि 16 से लेके 18 17 तक
15 से लेके 17
15 से, ये कहाँ से बोले? It is beyond the complaint. It is beyond the complaint and contrary to the complaint. And it is beyond your legal notice also. Legal notice में भी यही कहानी बोले हैं जो complaint में बोले. So therefore the check which was issued and was mentioned in the agreement, by that time the amount was not paid. Evidence में बोल दिए कि 15 से दिए थे लोन. Evidence में कैसे how? हमको डील करना पड़ेगा ना. आप लोग तो क्या बोलेंगे? कुछ बोल नहीं सकते. कुछ बोलेंगे तो आप लोग को बुरा लग जाएगा, इसलिए नहीं बोलेंगे. ठीक है ना? यही है ना कहानी कि एग्रीमेंट के दिन तक लोन नहीं हुआ था, लोन एग्रीमेंट के बाद हुआ था. और जिस दिन चेक इशू हुआ था उस दिन देयर वाज नो लीगली पेएबल डेट.
For final disclosure, item 1, Conversion 352 of 2023.
Yes.
May please read the court minutes. With the permission of the court minutes, may I be allowed to serve the written notes of argument along with the copies of the judgment upon which I am relying. I have served a copy to the opposite party.
I hope there is no defect, no surviving defect.
In this present case?
Yes.
No, not at all. Not at all.
Yes, tell us.
Before going into the reading of the entire complaint case and the depositions of the persons.
No, we are not going to reappreciate your
Obviously,
evidences. You are straight away come to the point of law and start, and then you can come to the facts.
The most important point
You
of
formulate
law,
your points of law.
The most important point of law in this present case is with regard to impropriety and incorrectness of the judgment.
Sorry?
Impropriety and incorrectness of the judgment. There is no illegality.
You see, that is the scope of, you just formulate the point of law which according to you has a reason, could be a reason to interfere with it.
Preponderance of probability which has been raised by the defense has not been taken into consideration by the trial court as well as by the appellate court. That is the first issue.
Just a moment.
Minds.
Yes.
Yes. The second issue, my lord, says that the complaint itself is defective.
Why?
For that matters, I have to show it from the record. So these are the only two issues, matters on which I'll be engaging in the entire case. So now, let me give you a brief fact about this case, what is it all about. The complainant and this particular accused.
You are for private party?
Yes, please.
Have a seat. Back there.
The complainant and the accused are known to each other for a very long time, according to the complainant. In his complaint, he has mentioned that in December 2017, that is paragraph number 2, in December 2017, the accused approached the complainant and asked for a financial help to a tune of rupees 15,25,000 rupees. That particular amount was given to him in the year 2017. Now, this particular amount, there are two parts. In this particular amount, certain amount has been given from the account of complainant's sons and complainant's wife account. And few amount has been given in cash. There is no money receipt.
Who had issued the check?
For the
Who is
complainant's,
the drawer of the check?
the drawer of the check was, according to the complainant, was the wife of the complainant and the son of the complainant.
They are not accused.
No, they are the wife and son of the complainant.
Okay.
May I clarify? From their account, some amount has gone to the account of the accused.
All right. From the account of wife and son also,
Of the
some
company.
account has gone. Some
Yes.
amount has gone to the accused.
Yes.
And the rest of the amount has been given in cash by the complainant. Months. Now, with regard to the cash, as well as the amount that has come directly in the bank account, there is a transactional history. With regard to the cash amount, there is no receipt, there is no money receipt, no nothing. But what has happened, that an agreement was subsequently entered and executed between the petitioner, that is the accused, and the complainant. That agreement
Dated.
dated 6/12/2017. That is Exhibit 3.
This is between the accused and the complainant.
And the complainant. In this particular agreement, there are 4 things which is of paramount importance. First and the foremost thing is that the amount which has been given, for which 3 checks have been issued by the accused to the complainant, which are the subject matter of this present case.
This agreement has been exhibited.
It is exhibit
This is
3.
the exhibit number.
Exhibit number 3. I have mentioned everything in my written statement minutes.
All right. Okay. So what do you just come to the point? What
Yes, I am
happened
coming to the
thereafter?
point minutes. But first, I need to show that how I have manufactured my defense. That needs to be brought on record, which the learned lower court below has not taken.
No, first come to the prosecution case. Complete it.
The prosecution case. Now, this entire amount was given to me in December 2017. Subsequently,
No, there was an agreement in December 2017.
and the amount was also given in December 2017. Para 2 of the
Okay. The account from the account of son and wife and cash.
and cash. There is no money receipt. Subsequently, what has happened, my lets, that there was the mentioning of the checks numbers are there in the complaint, and then there was an assurance given by this particular petitioner to the complainant that I'll return the entire amount within 1 month. That is on 31/1/2018. This particular agenda is also mentioned in the agreement. On 31/1/2018, I defaulted in giving the entire amount to the concerned complainant. The concerned complainant continued and endeavored, asked me, requested me to give the entire amount, which I did not. Pursuant thereto, a demand notice was raised on 11/6/2018. I received a demand notice on 12/6/2018, just 1 day thereafter. Then after 12/6/2018, a time period of 15 days was given to me. When this particular 15 days was lapsed, the complaint was filed. The reason cited in the present case was account close, not insufficiency of funds, but it is the same thing. Now, what is this agreement? Now, coming back to the agreement, this is marked as exhibit number 1, the complaint.
With objection or without objection?
Oh, sorry, the passbooks of Sulochana Devi, the wife of the complainant, they are marked as exhibit number 1, 1 by 1 and 1 by 2.
I'm just talking about this. This agreement has been exhibited or not?
Yes, yes, yes. Exhibit 3.
With objection or without objection?
Without objection. Without objection. Now, in this agreement, there are 4 most important and pivotal things. Number first, it has been stated that the entire amount needs to be paid by 31/1/2018. That is point number 1. Point number 2 is that 3 checks has been given. The amount has been mentioned. The name of the bank has been mentioned, but the dates are not mentioned. The third important point is that these checks were given as a security, which the learned lower court below has appreciated. But apart from this particular checks, the property papers of the accused was also handed over to the complainant as a further security, as a collateral. So apart from check which was issued as a security, there was a subsequent security given as a collateral for that particular checks to be honored. That was the house and property papers. And the fourth important point was that in the event of any default, or in the event that there is a miscommunication or there cannot be a situation where we can resolve it, the entire matter needs to be resolved amicably and not from the court. These are the 4 points which was mentioned in the agreement. Now in this agreement, there are 2 witnesses. They are CW2 and CW3 of this particular petition. Now once the agreement was executed, the checks were given, the checks were defaulted. Subsequently, case was brought on the court. Now, in the complaint case, they have stated that the entire amount was given on December 2017. In the deposition, CW1 says that the entire amount was given between 2015 to 2017. So whatever amount was given prior to 2017, subsequently that is not being taken into consideration in the complaint case. What he is arguing is that December 2017 I have given the entire amount. And the entire amount was given in 2017 and then the agreement was entered.
You have not still entered within the realm of revision judicial.
I'm coming, madam.
I'm waiting for you to enter
coming
there.
that. But for that, madam, at least the facts needs to be pleaded. So now, this particular point was missing. I raised a contention before the learned lower court below, the preponderance of probability, that this particular check was given to the complainant for the purposes of securing a loan from the bank. So the question came as to why did you give this particular check to him for the purpose of securing the loan?
How did it find its mention in the agreement?
Which way, ma'am? Which one?
These 3 checks,
Yes, ma'am.
it found mention in the agreement
Yes.
between both of you.
Yes.
Yes. How did it find mention in the agreement?
These checks were
If
mentioned.
it was by way of security only,
Yes.
and that too for a loan account.
For a loan account.
Yes.
So for that, I have stated that at the time of securing the loan account, when I had handed over the property papers to the concerned complainant, certain checks, blank checks with no date mentioned, was handed over to him. And certain documents along with AADHAAR card and PAN card, certain documents was also handed over. And then there were certain blank papers on which I have signed in the top and in the last page, which has been used to frame this particular agreement. Now in the agreement, the date is not mentioned. But CW2 says that the checks were given on the date of the agreement. That is on 6/12/2017. So if the checks were given on 6/12/2017, so from 3 months thereafter, the checks will be invalidated. So even on 31/1/2018, if I take that into consideration that the agreement was framed and the agreement was formulated and executed, even after 3 months thereafter, the checks could have not been presented before the bank for encashment because the check would invalidate. So what he did was, he rewrote the date on the check, made it presentable before the bank to look like that the check has been issued recently. And then pursuant thereto, he presented a check before the bank. So my entire contention, my entire defense that I had taken that the check was issued for the security purposes
I
and for
still
the
don't
security
get
of the
it.
loan.
How do you say there is a cash transaction, there is a there is a transaction from the account of wife and son, and then you say that certain amount was also received by you in cash.
Not
Right?
by me. Yes, from cash from the complainant. Yes.
Right.
As far as the amount.
And just a moment.
Minutes.
So debt is there.
Yes, that is there.
Debt is there.
That is there.
Then how do you say it's a security amount?
Let me clarify. As far as the debt with regard to the wife's and son's account was concerned, we have repaid it back. When we filed criminal appeal in this present case before the London lower court, we gave 65,000 rupees. We have submitted 65,000 rupees to Nazara. The complainant has taken it up. After preferring the revision application, the entire 20% of the amount we were directed to pay, we have paid it to the Nazara. Whatever amount was given in checks from the accounts of the son and the wife has now been fully paid. With regard to the cash amount, there is no proof to that effect. The only proof that they have is this check, which they are saying that this particular check has been issued only for the purpose of setting of the liability in whole or in part. But the question that comes here is, my lords, that the debt itself is a negative word. It needs to be a legal enforceable debt. So what was the legal enforceable debt here?
The cash?
The cash amount, for which there is no proof.
No, need not be.
So if the cash amount is not proved,
need not be. When you issue a check, there is a presumption.
The presumption is under section 118A.
Is it your case that you never received any amount on cash?
I am saying, my lords,
Is it your case that you never received any amount on cash?
I have stated that I have not received any amount from this particular company.
Where have you stated?
In my deposition, I have stated that I have not received
Did you
anything.
cross-examine them on this point?
Yes.
You can say many things in your deposition.
In that situation, CW1, the complainant himself, whether he is saying a truth about the cash being paid to me, is also susceptible to rebuttal, is also susceptible to suspicion, because he does not have any specific evidence to prove otherwise.
First, there is a presumption, and then only there is a rebuttal.
When there is a presumption under section 118,
How do you break that?
when there is a presumption under section 118A and under section 139, the Supreme Court says that these particular presumptions are not something that cannot be rebutted. It is a rebuttable presumption.
Yes.
And for the purpose of rebuttable presumption, you only have to raise a probable defense.
What defense have you raised?
I have raised this defense that this particular cash, this particular amount, whatever has been given to me, that was never given to me in the first place. The amount was given to me, I have returned it back. But this particular papers, this particular check was never given for the purpose of legal enforceable debt.
Did you say that you never got the money in cash? Was it your case that you did not ever receive anything on cash?
Let me see the deposition.
Now then the second question would be,
My
you want
words.
to argue that this check was issued not for payment of this debt,
Yes.
but for some other purpose.
Yes. So for other
So
purposes.
therefore
Yes.
there is a presumption.
So therefore the
Right? And
presumption.
then you have to dispel that.
Then ma'am, the rest.
No, first you tell us, was it your case that there
Let
was
me
no
see.
cash transaction?
I'll show.
You must have responded to the legal notice.
No, Manoj, I have not responded to it.
You were examined as PW?
DW1.
Sorry, DW1. With a complainant?
Complainant is CW. May I be allowed to read minutes?
कंप्लेनेंट ने मुझे बैंक से लोन दिलाने का आश्वासन दिया, इसी आश्वासन के साथ मुझसे ब्लैंक चेक लिया है। बैंक से लोन लेने का इस आश्वासन से क्या लेना देना?
He was working as a bank officer. No.
So what?
The complainant.
Now, how does that make a difference? We don't know how this blank issuance of blank check can be correlated to a bank loan.
Let me rephrase it. This particular complainant, he was working as a bank officer way back in the year 2012. He was superannuated. Since we were good friends, I approached him. That is the case of the complainant. That we were very good friends. I approached him and I told him that I want certain sanctioning from the bank. He told me that there will be a collaterals, and for that purposes checks were given and the property papers were handed over to him. Now, the question that comes here is that if he could not have got that particular loan sanctioned, he should have returned that check.
What is the date on which you delivered this check according to you?
6/12/2017.
6/12/2017.
Why I am saying so? Let me prove it to you. Minutes. This is DW2 Panchuram. He has stated in paragraph number 20. Agreement के समय 3 चेक दिया गया था. The agreement is, the date is quite clear. 6/12/2017. So agreement के समय 3 चेक दिया गया था. DK सिंह ने कंप्लेनेंट को दिया था. चेक इतना के थे, 2 चेक थे, 2,65,000 के 1 चेक. So it is very clear that the checks were given on the date of execution of the agreement. Now, when the checks were given, under section 118A and under section 139, a presumption is drawn that a check has been issued for the purposes of discharge of a legal enforceable debt. I am on the same point that the legal enforceable debt should be something that needs to be proved by the complainant in the first place. What he is trying to prove is 2 things. Number 1, he is saying that the amount has been transferred from the account of his son and his wife. Very well, that has been returned through via judicial orders. As far as the cash is concerned, he is what he is trying to do is he is camouflaging his entire demand of cash by showing that there was the issuance of 3 checks, and as such, the probability is upon the accused to show that the presumption has not been raised. So this is the case. On December 2017, the entire amount has been given according to the complainant in the complaint petition. In the deposition, he has tried to improve his case by saying that the entire amount has been given between 2015 to 17. Then he said that I do not have any authorization from my wife and son to lodge this case, but that is a separate thing. Under section 142, he has the right. He can do so. But then he also says that there is no date in the agreement. That is the words of the complainant. Now the words of the complainant has to be taken into consideration, or the witness's words has to be taken into consideration. Because the witness says that on the date of the issue, at the date of the execution of the agreement, the checks were given. These are the probable defense that I would like to raise before this honorable court. That I have tried to make out my case before the learned trial court, and the learned trial court should have taken that into consideration and should have posted certain questions on me. Whatever friction I am getting from this honorable court should have got from the learned trial court at that point of time. That why did you issue the check to the concerned person? You could have directly approached to the bank. Why did you give your property papers to him? Even today, till today, the property papers are with CW1. He has stated that in his deposition. The property papers are still mere paas. He has stated that in paragraph number 25 and 26. ये बात सही है कि एकनामा में तय हुआ था कि अभियुक्त द्वारा पैसा वापस किए जाने पर उसके घर के कागजात लौटा दिए जाए। मैंने अभी भी मूल कागजात मकान का मेरे पास ही है। These are the statements given by the complainant. So I am asking my lords that if it is a legal enforceable debt, as what the complainant is saying, that is a legal enforceable debt, I have given you this particular amount as a friendly loan. What was the purpose and what was the occasion to take my property papers in the first place? I approached to you because you were my friend. You told me that you were working in the bank. This is not my words. Just the words of
You
the
could
complainant.
have given your property papers as security to the loan.
I actually wanted to do that only. I approached him for a specific
No,
purpose.
no, as a security to the loan, not from the bank, but from the private respondent.
But this particular security could have only been given to him if I have taken certain amount from
No,
him.
you have taken some amount.
I have taken in
Your
the-
wife and children.
Yes, that amount has already been rebutted. That I have already deposited it back to him. If the opposite party says that it has not been deposited, let me know. I have done that by a judicial order. This honorable court has asked me to.
But that is pending. That order is subject to the result of this case.
Yes, but that
Yes, sir.
amount has been already been deposited.
Might have been deposited.
Yes. So as far as the report, as far as the debt, legal enforceable debt with regard to the amount of the wife and son is concerned, that has already been paid. As far as, because there was a proof of that, he has attached the passbook reports of his wives Roshni Devi and Ashish Kumar to prove that yes, such and such things has happened. But as far regards of the cash transaction is concerned, there is no proof of that. So even though for the sake of brevity of the argument, I do consider that at that point of time there is no cash transaction. Or if there is a cash transaction, the person has not given any money receipt. He should have mentioned that in his deposition that I asked for the money receipt and he has not given it to me. That would have shown a malafide on my part that after taking the money, I have not given a money receipt to you. The question again comes formulation here is that if certain amount has been given from the account of your wife and your son, why not the entire amount? You could have deposited the same amount into your wife's account or your son's account and you could have given it to me.
Are you away from the society?
No.
Part cash and part checks transactions नहीं होते हैं. It is so
होते हैं,
common.
होते हैं.
Then why do you say?
लेकिन पार्ट चेक से अगर कैश ट्रांजैक्शंस हो रहे हैं तो उसको मैम अगर कैश ट्रांजैक्शंस भी अगर हो रहे हैं तो उसको साबित तो करना होगा. ये क्या साबित करने की कोशिश कर रहे हैं कि आपने जो चेक दिया है उसे प्रिजम्पशन ड्रॉ हो जाता है कि आपने मुझे चेक दिया, जबकि सुप्रीम कोर्ट कहता है कि सिर्फ चेक देने से नहीं होगा, आपको लीगल इन्फोर्सेबल डेट दिखाना होगा कि लीगल इन्फोर्सेबल डेट
कौन सा judgment rely करते हैं?
ये जजमेंट है.
Straight away you come to the judgment on your proposition that mere issuance of check is not sufficient to draw a presumption.
उस जजमेंट में मैं कर्नाटका हाई कोर्ट का जजमेंट है वो
अब कर्नाटक का अभी आप सुप्रीम कोर्ट का नाम लिए ना, तो जिनका नाम लिया
ये
वही का
चार
judgment
जजमेंट जो है सुप्रीम कोर्ट के जो
हाँ,
मैंने
ठीक है.
लॉर्डशिप को दिया है,
कि presumption ऐसे नहीं होता.
ये तो प्रिजम्पशन के लिए ही मैं बता रहा हूँ.
बताइए. You
Presumption
just
में
said 4 judgments of Supreme Court on the point. I want to see that judgment. Which
yes,
judgment
but
should I
first
take?
perhaps I
up?
would like to raise at least the facts needs
No,
to be.
I'm hearing you for 20 minutes on facts in a revision jurisdiction where there are concurrent findings. So you straight away come to the.
Ma'am, the concurrent findings are flawed. That is why I am coming to this particular fact.
That's.
See, the preponderance of probability.
You just made a statement that Honorable Supreme Court has said that mere issuance of check will not draw any presumption. Show me one judgment. When you make a statement, be very, very
Can I research
particular.
it right now, Manoj? Because I have seen it.
Research. You said that you have
No, I have
filed
4
judgments. You have written. You have filed written
I have 4
submissions.
judgments, but this particular judgment has been passed by Karnataka High Court.
No,
which
you
says-
said that Supreme Court has said. I just, I'm very particular about words.
Yes.
The moment you make a statement on the basis of any judgment of the Honorable Supreme Court, and if I differ, then I would certainly like to see that judgment because
course,
my mind is stuck. I can be wrong, isn't it?
No, we do not
No,
expect.
no. Why not? I expect that I can be wrong. I have no hesitation in saying that I can be wrong.
The words, I am only saying 2 things importantly. I am saying that when defense has not been taken into consideration, which the learned lower court should have taken that into consideration at that very threshold. Because if that would have been taken into consideration, there would have been certain questions on the basis of which the entire judgment could have a different object altogether. Issuance of check
You
gives
have
a
examined yourself as a witness.
TW1.
Let us see. Let us read your evidence.
Yes, perhaps. May I be allowed to read?
Yes, please.
Devendra Kumar Singh, DW1.
Just a minute. Yes, please read it.
जिस केस में गवाही दे रहा हूँ, इसे देव नारायण पोद्दार ने किया है, इसकी मुझे जानकारी है. मैं एक कंप्लेनेंट को 2.5 साल से जानता हूँ. वो बैंक में एम्प्लॉय है, इस वजह से जानता हूँ. कंप्लेनेंट का दावा कि मैंने उससे 15 लाख रुपए लोन लिया था, ये गलत है. कर्ज वापस करने के लिए 15,25,000 का चेक दिया जाने की दावा गलत है. मुझे इस बात की जानकारी है कि मेरा चेक कंप्लेनेंट के पास था. कंप्लेनेंट ने मुझे बैंक से लोन दिलाने का आश्वासन दिया था, इसी आश्वासन के साथ मुझसे ब्लैंक चेक लिया था। चेक के अलावा भी सादे कागज पर मेरा सिग्नेचर भी लिया था। मुझे लोन नहीं दिलवाया। मैंने अपना चेक मांगा तो मुझे मेरे अपने चेक वापस नहीं किए। इस चेक से 15 लाख वसूलने की धमकी देता था। मैं वापस मांगता रहा और कंप्लेनेंट ने चेक बाउंस कराकर केस कर दिया। कंप्लेनेंट से जो लोन दिलवाने की बात हुई थी उसकी जानकारी किसी को नहीं थी। कंप्लेनेंट का दावा है, झूठा दावा है, फॉल्स केस दिया गया है, क्रॉस एग्जामिनेशन हुआ। कंप्लेनेंट के साथ पहली बार इसी चेक से संबंधित लेन देन हुआ है, इसके अलावा किसी दूसरा लेन देन की बात नहीं हुई। मैं बिजनेस करता हूँ, फर्दर क्रॉस एग्जामिनेशन, मैं बिजनेस करता हूँ। मुझे इसकी जानकारी नहीं है कि वादी किस बैंक में काम करते थे और कब सेवानिवृत्त हुए। मुझे सादे कागज पर सिग्नेचर कराया था, ऊपर और नीचे साइन कराया था। मुझे याद नहीं है कि कितने कागज के साइन कराए और किस डेट को साइन कराया था। मैंने पैसे का कोई लेन देन नहीं किया, कोई चेक भी नहीं दिया। स्वतः कहते हैं कि लोन के लिए चेक दिया और लोन के लिए मैंने चेक दिया। 2018 में मुझसे चेक लिया था, मैंने कोई एग्रीमेंट नहीं किया। मुझसे सादे कागज पर साइन कराया गया। एग्रीमेंट डेटेड 6/12/2017 को पहचानता हूँ, इस पर मेरा सिग्नेचर है, सिग्नेचर एग्जिबिट ए मार्क किया जाता है। मैंने 2018 में कंप्लेनेंट के ऊपर केस किया है, तारीख याद नहीं है।
ये कॉन्ट्रडिक्टरी नहीं है, मैंने कोई एग्रीमेंट नहीं किया था।
हाँ,
एंड देन यू एडमिट योर सिग्नेचर ऑन द एग्रीमेंट आल्सो।
सिग्नेचर एडमिट है क्योंकि सिग्नेचर तो मैंने किया ही था। एग्रीमेंट पे सिग्नेचर नहीं रहे, प्रूफ ऑफ डॉक्यूमेंट नहीं है हमारे। सिग्नेचर को किया गया क्योंकि वो तो बोल ही रहे हैं कि हमसे सारा कागज में साइन किया गया। सिग्नेचर को वेरीफाई वो कैसे कहेंगे कि नहीं ये सिग्नेचर है? प्रूफ ऑफ डॉक्यूमेंट नहीं किया कि हाँ ये प्रूफ और ये जो
चेक
डॉक्यूमेंट
में आपने साइन किया था?
चेक में हम लोग ने साइन किया था। तो चेक तो हम लोग पहले ही दिए थे, पोस्ट डेटेड चेक था, मतलब डेट तो था ही, ऐसे ही चेक दिया गया था ब्लैंक, मतलब ऊपर में जो डेट था वो लिखा हुआ नहीं था, सिर्फ साइन था, अमाउंट लिख कर दिया गया था, भरना उनको था, वो अपना भर देते थे। मैंने 2018 में कंप्लेनेंट के ऊपर केस किया है, तारीख याद नहीं है। कंप्लेनेंट ने मुझसे पैसा वसूलने की धमकी दिया था, जिसके खिलाफ केस किया था। ये केस माननीय न्यायालय सत्यभामा कुमारी के यहाँ पेंडिंग था। ऐसी बात नहीं है कि मैंने ये चेक कंप्लेनेंट को फ्रेंडली लोन के एवज में दिया था, बल्कि लोन पास करने के लिए चेक दिया गया था। ऐसी बात नहीं है कि इस केस में वादी 2012 बैंक से सेवानिवृत्त हो गए थे और मेरे कथन कि मैंने ये चेक लोन पास कराने के लिए दिया था, ये झूठ है। मुझे लीगल नोटिस नहीं मिला। मैं स्नातक तक पढ़ा हूँ। सुलोचना देवी कंप्लेनेंट की पत्नी है, उसे जानता हूँ। सुलोचना देवी के द्वारा मेरे खाते में कोई रकम नहीं भेजा गया है। मैं कंप्लेनेंट को 3 चेक दिया था। मैं चेक की मांग किया था कंप्लेनेंट से। 2018 में चेक की मांग की थी। मेरे विरुद्ध सिर्फ यही केस चल रहा है और कोई केस नहीं चल रहा। मेरा लोन पास नहीं किया था। चेक पर सारा हस्ताक्षर मेरा है। मैं ब्लैंक चेक दिया था। दिस इज द deposition of the DW1. May I also be allowed to read the deposition of CW1? Just for appreciation in that. As with the permission of the court, CW1 members, if I may be allowed.
You read the cross-examination, lest he must have supported his case.
Madam,
Read it.
the program starts from paragraph number 14.
24.
No, madam, paragraph number 14. Next.
Para number 14.
Madam, at the down at the very bottom of the page, madam, where the examination chief gets over.
11. Then I have further cross-examination.
11 के बाद मैम 12 and 13 भी होगा।
हाँ नहीं है।
नेक्स्ट पेज
12-13 yes
अभियुक्त से दोस्ती थी, क्रॉस एग्जामिनेशन। अभियुक्त से दोस्ती थी, आना जाना था, इसलिए जानता हूँ। मुदाले के अलावा किसी को दोस्ताना कर्ज नहीं दिया। डेफर ड्यू टू पॉसिबिलिटी ऑफ टाइम। नेक्स्ट 16 मैं रिटायर्ड बैंक कर्मचारी हूँ। 31 जनवरी 2012 को मैं रिटायर हुआ था। ये बात सही है कि एग्रीमेंट किस दिन हुआ था, एग्रीमेंट में इसका तिथि मेंशन नहीं है। मैंने अपने पत्नी तथा बेटे को इस केस में गवाह नहीं बनाया है। मैंने एग्रीमेंट में पत्नी तथा बेटे के गवाह नहीं बनाया है, ये बात सही है। ये सही बात है कि पासबुक 1 एग्जिबिट 1/1 तथा 1/2 में टोटल चेक अमाउंट से कम पैसे का ट्रांजैक्शन दिखाया गया है, क्योंकि बाकी पैसा कैश में गया। ये बात सही बात है कि कैश में दी गई राशि की कोई प्राप्ति रसीद नहीं। ये बात सही है कि तीनों प्रसंगत चेक मेरे पत्नी या बेटे के नाम पर नहीं है। ये बात सही है कि मेरी पत्नी तथा मेरे बेटे ने मुझे कोई ऑथराइजेशन नहीं दिया है कि उनके द्वारा दिए गए पैसे के लिए मैं केस कर सकता। मैंने जो रकम कैश में दी थी वो रकम मेरे पास से दिया था। ये बात सही है कि मैंने कैश में दिए गए पैसे के बारे में केस में नहीं लिखा है कि तो पैसा मैंने अपने पास से दिया। पैराग्राफ नंबर 24 ये बात सही है कि
just a moment इस पूरे के पूरे क्रॉस एग्जामिनेशन में there is not even a word about loan.
What about
Not even a word about loan.
loan?
कुछ नहीं है कि लोन के चलते पैसा दिए, ऐसा आपने क्रॉस एग्जामिन किया ही नहीं है। उसके बाद डिफेंस एविडेंस देने से क्या होगा? डिफेंस एविडेंस तो कुछ भी दीजिए। क्रॉस एग्जामिन तो विटनेस कंप्लेनेंट को करना था ना इस पॉइंट पर, that this was given by way of security and you were supposed to give me the loan and you projected yourself as a bank manager. He says that he has retired in 2012. The transaction is of 2017.
Yes.
Yes, and there is no cross examination on the point that you are arguing. So where is the occasion to dispel the presumption?
With regard to the loan,
Yes, you said that an amount was to be given to you by way of loan, and by way of security you had given this check. That was your argument
Yes.
since beginning,
yes,
right?
yes.
Where is that cross examination of the complainant on this point?
That is not there in this.
Then the entire evidence of the complainant is intact.
Then with regard to DW1,
It is of no use.
why?
No,
Well, it's in
because the
section
complaint.
350.
Why means why तो आप judgment में देखेंगे फिर आप उसको challenge करेंगे,
Why not? In section
right?
350.
इसलिए why इस तरह से पूछने का कोई scope नहीं है, right?
In section 350,
We'll
I
see
am.
I just thought that I should put that question to you. I put that question.
There is no mentioning of any loan.
Admittedly, there is nothing in the cross-examination of the complainant regarding loan, and there is nothing that this particular check, these 3 checks were given to him by way of security.
So when I put this question to the accused in DW1,
That's right. We have seen it. Now you just read the impugned judgments.
Manoj, may I be allowed to at least raise this particular issue?
You see,
Manoj, just to.
no.
In
you see-
DW1, when I have raised this,
You see, we are scrutinizing the judgment of 2 courts, and we will interfere only if there is a perversity. So kindly come to the impugned orders and show me the perversity in the impugned
मैम
orders.
DW1 से जब हमने स्टेटमेंट पूछा था, जब मेरा एग्जामिनेशन चीफ हुआ था DW1 में, तो क्रॉस एग्जामिनेशन कंप्लेंट नहीं किया।
बहुत अच्छी बात।
वो उन्होंने भी इस चीज को डेफर नहीं करा।
कोई बात नहीं, आप हमको ये बताइए कि impugned order का क्या perversity है। You just come.
इसी बात को इम्प्यून ऑर्डर ने कंसीडर नहीं किया।
ठीक।
यही पर्वर्सिटी पे हम लोग फोकस कर रहे थे कि दिस पर्टिकुलर थिंग
डिफेंस विटनेस के क्रॉस एग्जामिन को कंसिडर नहीं किया।
डिफेंस विटनेस के एग्जामिनेशन चीफ एंड क्रॉस एग्जामिनेशन दोनों को कंसीडर नहीं किया। ये बात सिर्फ एक ही चीज पे आकर अटक गई कि हाँ 3 चेक्स दिए गए थे, प्रिजम्पशन आपके फेवर में।
Absolutely an afterthought.
लेकिन ये चीज काफी नहीं थी मैम.
Absolutely an afterthought.
लीगल इन्फोर्सेबल डेट दिखाना जरूरी है, मैंडेटरी है अकॉर्डिंग टू द सुप्रीम कोर्ट आल्सो.
उस पर आप फिर सुप्रीम कोर्ट, आप हमको बताइए ना, आप फिर सुप्रीम कोर्ट पहुंच गए तो आप हमको जजमेंट दिखाइए कि लीगली एनफोर्सेबल डेट जो है कंप्लेनेंट को प्रूव करना पड़ेगा. बताइए. Then we will start reading the section in a different way altogether. बताइए कहाँ पर?
Yes, ma'am. This is a judgment of Basalingappa versus Mudi Basappa.
Yes. You just come to that
Paragraph number 23.
para 33.
23.
20. Okay.
Maybe you have to read minutes. We have noticed the ratio laid down by this court in the above cases on section 118A and 139. We have summarized the principle enumerated by this court in the following manner. Once the execution of cheque is admitted, section 139 of the Act mandates a presumption that a cheque was for the discharge of any debt or other liability. The presumption under section 139 is a rebuttable presumption, and the onus is on the accused to raise the probable defense. The standard of proof for rebutting the presumption is that of preponderance of probability. To rebut the presumption, it is open for the accused to rely on evidence led by him, or accused can also rely on the materials submitted by the complainant in order to raise a probable defense. Inference of preponderance of probability can be drawn not only from the materials brought on report by the parties but also by reference to the circumstances upon which they rely. That it is not necessary for the accused to come in the witness box in support of this defense. Section 110 imposes an evidentiary burden and not a persuasive burden. It is not necessary for the accused to come to the witness box to support his defense. Now, on the basis of this particular assumption, on this particular ratio laid down by the Honorable Supreme Court, the Supreme Court has cleared that as soon as the cheque is issued, the presumption is raised. And then, for the purpose of shielding the accused from notorious actions against him, the Honorable Court has given a specific guideline that a presumption is rebuttable, it works on preponderance of probability, and you do not only have to take the defense of preponderance of probability, but you can also use the materials against you, or you can produce your own material to prove it. So here, my lords, I have taken the material of DW1 and CW1 into together. And thereafter, even at that point of time, in DW1, I have given my only probable defense. When that probable defense was taken into consideration, if that probable defense was not according to the law, that could have been questioned in re-examination of this particular witness, but that was not done. So at that point, at that threshold, a question should have come from the Honorable Court, from the learned court, that whether we have any evidence of that fact, that whether this particular loan amount or this particular amount has been given for social purposes. The agreement has not been dated.
Mr. Sahai, please appreciate
Madams.
that unless you show things from the judgment,
Yes.
I am totally non-receptive to your lecture.
Let me
Show me from the judgment,
Madams.
I'll hear.
Madams. From the judgment of the trial court. Madams. Paragraph number 16.
Trial court judgment,
Months. That was passed on.
okay, that's here.
May I start? That is dated 7th of March 2022. Months. Paragraph number 16.
Yes.
Now coming to the merits of the case. I have scrutinized the entire evidence brought on record very carefully. On the scrutiny of the evidence and entire records, I find that the complainant is well acquainted to the accused and had good relationship with the accused. I further find that the complainant has given an amount of rupees 15,25,000 rupees to the accused, and in discharge of the said legal debt, the accused has issued the impugned checks bearing number so and so, dated so and so, amounting to so and so. On presentation of the check, the same before the Bank of Baroda, Jamshedpur, the impugned checks got dishonored on 18/4. Legal demand notice was raised on 11/6/2018, will show that the complainant requested the accused person to pay the check amount, and a notice was sent through speed post on the very same day, that is on 11/6/2018. The said legal notice was received by the accused on 12/6/2018 as per the postal track report, Exhibit A. Further, admittedly, complainant petition is filed on 5/6/2018. On the aforesaid premise, this court is satisfied that the complainant has been able to prove all the ingredients of Section 138 of the NI.
How is it 5/6/2018?
Typographical error. 5/7.
The material date का typographical error.
The complaint was filed on 6/7.
6/7.
On the aforesaid premise, this court is satisfied that the complainant has been able to prove all the ingredients of Section 138 of the NI. Thus, this court can take safely statutory presumption under Section 118A and 139 of the NI. Accordingly, this court takes presumptions as enumerated under Section 118 and 139 of the NI. Now, the only question remains to be adjudicated by this court is to see as to whether the accused has been able to rebut the presumption taken by this court under Section 118A and 139 of the NI. Having heard the learned counsel for the parties at length, and after perusing the entire documents, including the complaint petition, deposition of the complainant witness and the defense witness, exhibit and statements under Section 313 CRPC, this court is of the considered view that accused is unable to rebut the presumption taken under Section 118A, 139 of the NI Act in view of the following reasons. 1. Admittedly, the parties are friends. 2. Exhibit 1, 1 by 1, 1 by 2, Exhibit 2, 2 by 1 are the bank statements of the complainant wife and son issued by the Canara Bank and SBI Jamshedpur showing the details of the money transferred in the account of the accused through checks. These are the records. C. Most importantly, Exhibit 3 is the loan agreement dated 6/12/2017. Both the accused and the complainant are his signatory members. The sum and substance of this agreement that the accused admitted that he has taken the loan amount of rupees 15,25,000 from the complainant, and for discharge of this illegal debt, he has issued the impugned checks dated itna and amount of itna respectively. So, presumption has been taken on the basis of an agreement. D. Signature of the accused over the impugned checks and loan agreement dated Exhibit 3 is undisputed. No evidence is brought on record to abolish this fact that the accused has not signed either the impugned checks or loan agreement.
Yes, continue.
Further, the accused has admitted in his deposition and statement that he has issued the impugned checks for security purpose. In absence of any cogent evidence to demolish the signature of accused over agreement and impugned checks, can safely say that the accused has miserably failed to rebut the presumption drawn above. The witness of the loan agreement, namely Dilip Kumar and Panchuram, have been examined at CW2 and CW3, and they have supported the contents of the said agreement, and nothing has been elicited from their cross-examination to discard their testimonies. So far as the plea of the accused regarding the fact that the complainant has offered help to the accused in obtaining loan from the bank as he is the bank employee, and in response thereof the accused has issued the impugned checks only for security purpose, but the same was subsequently misused, seems to this court wholly unnatural and unbelievable. For the simple reason that if the accused was to obtain any loan from the bank, the accused should not have signed blank papers and checks and handed over the same to the bank. Furthermore, this plea seems to be unbelievable on the face of the document like bank statements and loan agreement and impugned checks. The argument of the learned counsel for the defense that the complainant is not the holder of the cause, as the wife and son have not given him authority for realization of money in question, has no force in view of the fact that the wife and the son of the complainant are his own family members, and as such, the money of the wife and the son can be said to be the money of the complainant himself. Furthermore, wife and son are not the agreement holders. Thus, this argument is hereby rejected. Hereafter, my lords, the argument of the learned for the defense that the complainant has mentioned for the first time in his cross-examination that the loan amount is given in installments between 2015 and 17, and the same fact is not mentioned either in the complaint petition, examination chief, or legal notice does not flick much of the eyes. Fact remains that the same, that the loan amount of rupees itna only. Cross-examination regarding payment of the installment is only speaking about methodology and the kinds of payment and nothing more. So this was the view taken by the learned trial court.
What about the appellate court?
Yes, please. I'll start reading from paragraph number 9 of the appellate court minutes. So far as the question raised by the learned defense counsel that the agreement dated 6/12/17 does not bear the date is concerned, it appears the same was prepared on 6/12/2017 before the notary public, and in this view of the fact, it will be inferred that the same was executed on 6/12/2017.
You read it from the portion where the court deals with presumption.
After paragraph number 6, after paragraph number 9, the court has dealt with a judgment of Bir Singh versus Mukesh Singh. Then thereafter, paragraph number 10, and then there is no mentioning where the court has dealt with presumption. In paragraph 8, members, they have mentioned the facts of the case and the exhibits for the entire.
And two witnesses to the agreement have also been examined.
Yes, CW2 and CW3.
They were present at the time of execution of agreement.
They say so, yes.
So they say so. There is no cross-examination from your side.
No, there is a cross-examination.
No, but there is no material cross-examination on this point.
On the point of taking of the loan.
No. You said that on the signed blank papers, this agreement was prepared.
Huh.
Right?
Yes.
So, but they are the witness to the agreement.
Yes.
Then,
Ma'am, whether I was present at the notary public while signing of that particular agreement, whether that particular statement has been given by this particular witnesses.
we'll see that.
That
That's
is
all.
not-
हाँ बताइए क्या बोलना है आपको?
It's in gradient of section 138 NI Act are intact in this case, Lords. Cheque was issued for a liability, and agreement was entered between the parties with regard to Lords an amount of rupees 15 lakh Lords. And in lieu of that agreement, 3 checks were issued. Some money was paid not from the bank account of Sulochana Devi, that is the wife of the complainant, and some amount was paid from the account of son of the complainant, that is Ashish Kumar. Lords, after depositing the check, they got dishonored, and a legal notice was issued by the complainant on 11/6/2018.
Where is the legal notice?
It is exhibit. Legal exhibit 6. Even after issuance of legal notice that he received on the very next day, he chose not to reply the same. That is, postal receipt is on is Exhibit 7. It was received on 12th, the very next day. From Jamshedpur. And the checks were issued for legal enforceable debt. An agreement was entered into the parties' notes.
Read the chief of CW1.
Millers. I am the complainant of this case and I have filed the complaint in hand against Devendra Kumar Singh, such and such, who is known to me since long, that the accused Devendra Kumar Singh has approached and requested to me for a friendly loan amounting to rupees 15,25,000. On the request of the accused Devendra Kumar Singh, I advanced him the requested friendly loan of 15,25,000 in installments on returnable basis without interest in between 2015 and 2017 by check and cash. I have advanced the said friendly loan to accused through checks bearing number such and such dated 18/8/15 plus for Sulochana Devi and Ashish Kumar. And these are the three original passbook of my wife, namely Sulochana Devi bearing account number such and such of Canara Bank Mangu branch Jamshedpur, and this may kindly be accepted 1 and 1 by 2. That further I had advanced a friendly loan to the accused through check bearing number such and such amounting 59,400, check number such and such amounting 52,700, check numbers 564,770 dated 12/4/16 amounting to rupees 30,000, check number 564,773 dated 2/5/16 amounting to rupees 62,670 from bank account of my son, namely Ashish Kumar, having bank account number such and such of SBI Mango branch Jamshedpur. These are two original passbook of my son, namely Ashish Kumar, bearing account number such and such of SBI Mango branch Jamshedpur, and these may kindly be executed exhibit 2 and 2/1. That thereafter the accused Devendra Singh entered into an agreement for the said friendly loan dated 6/12/2017. This is true and original agreement notarized dated 6/12/2017 in which 5 pages bearing signature of the accused and mine. This may kindly mark exhibit 3. That the accused had assured me that aforesaid friendly loan amount of rupees 15,25,000 only will be paid or returned by him within 31st of January 2018. That for repayment of loan amount, the accused had issued 3 checks bearing a number such and such amounting to rupees 6,30,000, 6,30,000, rupees 2,60,000 respectively, all dated 17/5/2018. The checks were dated. Drawn on Bank of India Sakshi branch Jamshedpur in favor of me for encashment with an assurance that aforesaid check would certainly be encashed on its presentation before the bank during its validity period. So there was nothing मिलर्स की 6/12 को हम एंटर किए एग्रीमेंट मिलर्स और 3 महीने के बाद का चेक लिया था. ये 17/5 डेटेड ही था. चेक पे उन्होंने डेट डाला था. That as per the instruction I have deposited such checks for encashment during the period of their validity which were returned unpaid to me on 18/5/2018 on account of account closed. Look, this amount to bounce. There are true and original 3 checks bearing number such and such respectively of 6,30,000, 6,30,000, 2,65,000 respectively, all dated 17/5/18 drawn on Bank of India Sakshi branch Jamshedpur, which were issued by the accused in discharge of his liabilities for encashment. These may kindly be marked as exhibit 4/4/1, 4/2. those are the three. These are the three return memo dated 18/5/18 against the check bearing number such and such. They may kindly exhibit 5/5/1/5/2. That I had informed the accused about the dishonour check, but the accused did not pay any heed. Thereafter, on 11/6/2018, a legal demand notice was served upon the accused through my lawyer by registered post with AD white postal receipt number such and such dated 11/6/2018, demanding therein to pay aforesaid 3 checks amount of rupees 15,25,000 only within a period of 15 days from the date of receipt of said notice. This is true and that this is true and original of his copy of the legal demand notice dated 11/6/18, which is of 2 pages bearing signatures on my lawyer theory and mine. These may kindly be marked as Exhibit 6. This is the original postal receipt number such and such dated 11/6/2018 under which the legal demand notice dated 11/6/18 was sent to the accused. This may kindly be marked as Exhibit 7. And that the said legal demand notice was received by the accused on 12/6/2018, under which, as per the tract consignment board, but even after the receipt of said legal demand notice, the accused failed to make the repayment of the said check amount within 15 days period as asked for. This is the coverage generated tract report bearing consignment number such and such dated which is 1 page. This may kindly mark as exhibited. So this is all the ingredients of section 138 are fulfilled now.
The query that your lordship raised with regard to the agreement being signed in the court where the witnesses were there. Kindly see paragraph number 11 and 12 of CW2 and 17 and 18 of CW.
He has entered into an agreement with Lord. He has entered
They are
into
not
an
even
agreement
sure.
with creating also stories.
They are not even sure as to where this agreement was made. Cross-examination for us.
There is nothing to rebut the case of the complainant. Unless he has one criminal antecedent also, this petitioner, with regard to same nature of offence.
रिविजन में क्रिमिनल एंटीसीडेंट का क्या रेलेवेंस है?
Just saying. Just saying.
तो इस तरह का बात ही क्यों करते हैं? क्रिमिनल एंटीसीडेंट, दिस इज एन अटेम्प्ट टू प्रेजुडिस द माइंड ऑफ द कोर्ट. फालतू बात है ना.
नहीं.
क्रिमिनल एंटीसीडेंट बेल है क्या? क्रिमिनल एंटीसीडेंट की बात करेंगे.
I बोल रहे.
कंप्लेंट कहाँ है? There is a complaint petition.
1 of 59.
Sorry,
One of
Page number 1 of internal page number 1 of 59.
one of
1 of 59. Internal page number 1 of 59.
I'm not able to get the complaint. Yes.
Complaint case number 1990 of 2018.
हमको complaint petition का copy चाहिए. Where is the complaint? Okay.
With the permission of the court.
What is the date of the agreement?
6/12/2017.
6/12/2017. What is the date during which the loan was disbursed?
On this loan was disbursed on
From 15 to 7.
only on December 2000. The loan from the account, the loan was given to me in the year 2015 and 16, and in cash I was given in 2017.
17. 15 to 17.
These three checks which were issued and was dated 17/5/2018. Fines mentioned in the agreement. Check number is mentioned, but
Check
date
number
is not mentioned.
Date is not.
Right? आप जरा देखिए complaint. Para number 2. Para number 2. पढ़िए जोर से पढ़िए.
That on the request of the accused, the complainant agreed to advance.
That during the first week of.
That during the first week of December 2017, the accused has approached and requested complaint for Sunday loan amounting to rupees 15
इसका
lakh.
मतलब दिसंबर 2017 तक लोन एक्सटेंड नहीं हुआ, राइट? एज पर द कंप्लेंट, रीड फर्दर.
That on the request of the accused, the complainant agreed to advancing the requested friendly loan on returnable basis without interest, and the accused prepared an agreement for the said friendly loan dated 16/12/17, and believing the contents of the said agreement, the complainant agreed to advance the accused.
Right? So agreement, on the date of the agreement, the amount was not advanced as per the complaint. Further पढ़िए. एविडेंस में आप बोल दिए कि 16 से लेके 18 17 तक,
15 से लेकर 17.
15 से, ये कहाँ से बोले? It is beyond the complaint.
Verse.
It is beyond the complaint and contrary to the complaint, and it is beyond your legal notice also. Legal notice में भी यही कहानी बोले हैं जो complaint में बोले. So therefore the check which was issued and was mentioned in the agreement, by that time the amount was not paid. Correct?
So that amount was paid, my lords, in the year 2015 and 16 from the account of Sulochana Devi and Ashish Kumar.
That is not your case in the complaint. Your case is that he came for a loan in the year 2017 and thereafter you agreed and an agreement was entered into and then the loan was given. यही तो है आपका केस. एविडेंस में बोल दिया कि 15 से दिए थे लोन.
यहाँ
एविडेंस में कैसे हाउ विल यू डू दैट? चलिए सुन लिए ना.
लेकिन
अब क्या लेकिन?
एनफोर्सेबल डिप्ट तो था, उन्होंने एग्रीमेंट तो एंटर किए थे.
तो हमको डील करना पड़ेगा ना. आप लोग तो क्या बोलेंगे? कुछ बोल नहीं सकते. कुछ बोलेंगे तो आप लोग को बुरा लग जाएगा, इसलिए नहीं बोलेंगे. ठीक है ना? यही है ना कहानी कि एग्रीमेंट के दिन तक लोन नहीं हुआ था, लोन एग्रीमेंट के बाद हुआ था. और जिस दिन चेक इशू हुआ था उस दिन देयर वाज नो लीगली पेएबल डेट. अब रिविजन में हम कितना एंटरटेन करेंगे इज वेरी वेरी डिफिकल्ट, बट दिस इज अ स्टोरी विच कम्स अप आफ्टर 1 hour ऑफ आर्ग्यूमेंट.
So sorry.
देखिए, criminal revision number 352 of 2023. Learned counsel for the parties are present. Counsel for the petitioner has submitted that there was no legally payable debt on the date the so-called agreement dated 6/12/2017 was executed. He has further submitted that as per the complaint, the complainant had approached the petitioner in December 2017 for a loan, and agreement was entered into on 6/12/2017, and thereafter the loan was disbursed. He submits that the check numbers have been duly mentioned in the agreement, and therefore on the date the check was delivered upon the opposite party number 2, there was no legally payable debt. He submits that the complainant had improved his case in his evidence by stating that the loan was advanced to the petitioner during the period from 2015 to 2017. The learned counsel has further submitted that the petitioner had raised a plausible defense before the learned court that there was no legally payable debt, but this aspect of the matter has not been properly considered, and he has relied upon the judgment passed by the Honorable Supreme Court in the case of Basil Gappa versus Mudi Basappa, and has referred to paragraph 23 of the said judgment. The learned counsel has submitted that this is without prejudice to the contention of the petitioner that the checks were undated, though the checks were signed but were undated, and a number of papers were a blank signature. The signature of the petitioner was taken on a number of blank papers. कुछ और बोलना है? Don't assume anything. हम तो record देखेंगे अब अपने हिसाब से. बताइए.
No, I'm not assuming anything. Because I would never assume anything.
You have to. Is there anything which I have missed out?
No, it's CW2 and CW3. There was a query from your lordship earlier. I was only reverting to that with CW2 and CW3 statements.
The learned counsel has also submitted that the evidence of CW2 and CW3, as well as the defense evidence of the petitioner, has not been properly considered. And therefore, the impugned judgments are perverse and call for interference. The learned counsel, appearing on behalf of opposite party number 2, has opposed the prayer and has submitted that there is no scope for reappreciation of evidences in revisional jurisdiction. There are concurring findings recorded by both the courts, and considering the scope of interference in revisional jurisdiction and the presumption under section 138 of the Negotiable Instruments Act, no case is made out by the petitioner. That's all. Judgment reserve करिए इसका.
Much of this.
Reserve मत करिए, डेट दीजिए. Reserve करने से it becomes a burden. कोई एक डेट दीजिए. डेट टू डेट दिया ना. 16 अगस्त. इस केस में हमको बहुत मेहनत करना पड़ेगा, एज आई सी. 30th August for judgment. कुछ तो क्रॉस एग्जामिनेशन के लिए आए हुए हैं. How much time will you take for cross examination? Because there are a number of matters which I have to take up. Those are out of turn. So I just wanted to know how much time. You said half an hour on the last date?
1.5 years.
अब जब 1.5 बोले तो 3:30 बजे आप फिक्स कराए. देखिए आपको रिकॉर्डिंग दिखाएं. आधा घंटा बोले थे. ये सब सुनने में हमको कोई गड़बड़ी नहीं होती लाइफ में. You said half an hour, तो हम बोले अच्छा 3:30 बजे.
1 घंटे में हम
1 घंटे में खत्म करेंगे ना, तो ठीक है हम लोग कंटिन्यू करेंगे, थोड़ा 15 मिनट हमको कुछ मैटर्स अर्जेंट है, 4 बजे वी विल स्टार्ट।